Okay, Chair, we're live on YouTube.
All right, thank you, members. I just got an indication from member Lecker that she's just trying to log on. So with your indulgence, if we can just give us another minute or two. Ms. Simon, is it possible that you can call in, or IT can call in member Lecker, please, to the meeting? We're struggling to log in.
Okay, Chair.
My apologies, members Winger and Brinkus.
Not to worry.
All in order, Chair.
I still get a no response from her, Chair. Clarence, do you perhaps want to try?
I'm just going to phone her on the cell phone, Chair.
No problem.
Hi, Chair. I've just contacted the Honorable Licker, and she said she will be joining the meeting in 5 minutes' time.
Okay, the meeting has started. I mean, I can't stop the meeting for another additional 5 minutes. on my own. Members, I'm going to ask you for your input into the matter. Do we break for 5 minutes and return in 5 minutes, or do we continue and then ask Honourable Lacker just to pick up what she missed out on?
5 minutes is fine with me, Chair. Thank you.
I'm in your hands.
All right, members. Then in the interest of allowing Honourable Lacker to deal with the technical issues, I'm going to then ask that we break for 5 minutes and that we return back at 1:15. Okay, thank you very much, members. It has just gone 13:15. If IT can just give me an indication if you're ready for us to continue.
Chair, I'm ready for you guys to continue. I've also tried calling Honorable Lekker in, but it seems there's still no response, and we're phoning her on her cell phone again. No answer.
Thank you very much. Members, I'm going to continue. I have had a discussion with Honorable Lekker. She asked me to tender her apology, but she will try. She's got network issues, but what she will do is she will join the meeting again. I see we've lost Honorable Brinkhuis. If Clarence, if you could just try and call Honorable Brinkhuis in again. All right, thank you very much, members. I see Honorable Brinkhuis has joined us again. Members, I'm going to go straight into the Honorable Brinkhuis. All right, members, I'm going to go straight into the proposed amendments as per item number 4 on the agenda. And I'm going to ask Ms. Simon to put up the amendments as received. I trust that you all had an opportunity to peruse those amendments. As you are aware, as per the decision of this committee, we've extended an opportunity for all members of Parliament to make inputs to or comments to the proposed amendments to the Code of Conduct for members of Parliament. And we have received some amendments. And I want to propose that I'm first going to deal with the proposed amendments as per the sections as it has been proposed, and then I'm going to allow an opportunity, members, if there's anything that you would like to add or comment on any section of the code. I'm also going to the registrar. If at any point you would like to make any comments or amendments, please feel free to participate. Members, are you all in agreement?
Yes, please proceed.
All right, thank you very much. Members, the first amendment is in the preamble, where it gives that levels, the word levels should be changed to the word spheres of government. Are you that first proposal? Do we accept it? Thank you very much. Then we move on to with your permissions, members. I'm going to skip definitions for last because that would take some deliberation and discussion. So I'm going to move straight to section 15, where the proposal or the proposed amendment is all meetings of the conduct committee are open, and the addition is until the registrar tables their report. Proceedings will then be closed to the public and non-committee members for the tabling of the report of the registrar and consideration of the report by the committee as set out in section 25, subsection 6(9) of the Code of Conduct, and thereafter the proceedings will open. Are there any objection, or do we accept that proposal?
Chair, do we want to read out section 6 to 9, section 25, 6 to 9?
Yes, we can do that. Let me just get it.
So basically it would be then 20, should be section 25. So the registrar shall provide the conduct committee a summary of the preliminary investigation and a proposed procedure for further investigation, including an assessment on the need for hearing. The conduct committee shall consider the report provided by the registrar and may call for further evidence from any other person relevant to the case. The conduct committee may accept the registrar's report, B, reject the registrar's report and refer it back to the registrar with further instructions and clear timelines to resubmit the report. C, reject the registrar's report, or D, it may call for further evidence. 9, the conduct committee must agree to the procedure for further investigation.
All right.
So those
Thank you.
deliberations would then be closed. And Chair, if I may, I support the proposal.
Thank you very much. Honourable Brinkhuis.
Yes, I'm also in agreement to accept that proposal.
Thank you very much, members. Section 25. The proposal is for the inclusion of section 10 under subsection 10 under section 25. If a further investigation is required, the registrar must proceed on the basis of the instruction of the committee. I would just like to amend that to conduct committee, if I may, just for a stylistic change.
Agreed to the amended proposal.
Thank you very much. Are there any objections to that proposal?
No objections, Chair. We agree.
Thank you very much. We move on to section 26, subsection 6. And as it stands, it reads, the conduct committee presides at the meeting or at the hearing, and then the conduct committee be removed and the chairperson of the conduct committee presides at the hearing. Any objections to the
no objections. Agreed, Chair.
Agreed. Agreed. Makes sense.
Thank you. Section 27, subsection 1, for the deletion of on his or her own, the registrar on his or her own, to be deleted. So it would read, the registrar, subject to the approval of the conduct committee, may initiate a preliminary investigation to assess the validity of allegations made in media reports. Any objection?
None.
No objection. Agreed.
Thank you very much, members. We move on to section 30. Under section D, the inclusion of one member of the official opposition and an inclusion of subsection E of one member of an opposition party. Are there any objections to that proposal?
None. That's for the appeals committee. Is that correct?
That's the appeals committee. Yes, Chifu.
No objection.
No objections.
Thank you very much, members. We move on to section 32. That's under penalties, and for the inclusion of two, a member found to have breached the code should be afforded an opportunity to make representation in writing and provide mitigating reasons before the committee recommends the imposition of one or more penalties. Any objections?
Agreed, Chair.
Honourable Wenger?
I'm just wondering whether the word may would be more appropriate. A member found to have breached the code may be afforded. For example, if there's a hearing and the person had already provided mitigating reasons, for example, then that might have already been covered. But in the case of, other types of breaches where there isn't a hearing, then obviously this provision would be appropriate. So I wonder if the word may wouldn't be better than should.
Yeah, that's fine from my side. Honourable Brunkes?
I got no problem, no objection against it, Chair. The
Alright.
word may can be changed to should, could, would, anything.
Well, from a legal perspective, it makes a big difference. So I take the point of the Chief Whip, and I think it's a valid correction. If we could just change that.
Yes.
Honourable Wingham?
I just wonder if the registrar would agree with that, or whether it's better to keep it as it is, as should.
Registrar?
Chair, I would agree with Member Wenger. The word may is perfectly apposite in this instance.
All right, thank you, members. So with that amendment, do we agree with the proposal
Agree?
of section 32?
Agree, Chair.
Thank you very much. And now we move to section 33(2), subsection B. With the inclusion of with reason at the end of subsection B, under conduct committee, appeals committee to report to the House. Any objections to that proposal?
No objections, Chair.
All right, thank you very much, members.
Sorry, just one moment quickly. I'm just cross-referencing with the code. 33(2)B. Okay, so it's an addition to the current 33(2)B.
Yes,
agreed.
it's an addition, yeah, just with reason. So it just reads for further consideration. We add with reasons.
Perfect. Agreed.
If the House refers it back. Then section 35. So again in subsection 1, it's just an addition to the current the current code. And with the adoption of the publication by a decision of the House.
Agreed.
Agreed, Chair.
All right. Thank you very much, Honourable Wenger and Brunkes. Members, can we now move back to definitions? And before we get to definitions, Registrar, is there anything that you would like to add, comment on?
Yes, Chair, I don't know if this is the appropriate time, but I spent a lot of time comparing the Code of Conduct Act with the Code of Conduct itself, and the Code of Conduct Act, as well as the Executive Members Ethics Act and the Executive Members Ethics Code, and obviously the Western Province Code of Conduct itself. And I came up with a number of, quite a large number of amendments that, if it's acceptable to the committee after we've dealt with the definition, that I would like to place before the committee, or alternatively circulate it in the form of a document. I'm in your hands, Chair.
All right. Can I ask if you could email that document to Ms. Simon for her to put it onto the screen for us to then, as soon as we've, actually, if we could deal with that first before we get to definitions. And then I'll provide you an opportunity to talk us through your proposals.
Fine, Chair. If you could just give me 5 minutes. I'm in the meeting on my tablet and my computer's in the other room. If you could just afford me 5 minutes, I can send it to Lynn.
All right, I'll do that.
Thank you, Chair.
All right, members, while we wait for the registrar, could we then, in the meantime, move over to the definitions? And by the time the registrar have sent the document to Ms. Simon, we can then deal with that. Are you all in agreement?
Yes, Chair.
Agree, Chair. Agree.
Thank you very much. So members, under definitions, the proposal is that working day or a day should be defined. A registrable interest, that the definition should include dependent child. I think that's what it is, but we need to look at expanding it to children. There's also a proposal that family members should include the minor children of permanent companions, and then we should then further look at defining permanent companions in as more than one. So that those are the proposals. Chief Whip?
Thank you, Chair. So on working day, I think that should be defined, Monday to Friday, excluding public holidays. But I also think there's a day that should be defined where it doesn't say working day, but day in the code, and that day should be defined as a calendar day. So as far as I recall, there's 2 different days appearing in the code. So for example, it will say within 30 days, a member should do X, Y, or Z. The word day should then day defined as calendar day.
Okay.
In fact, there's no working day. Oh wait, there is. There are 2. There's a working days and day. So I'd like to propose in that we split those up.
Okay. Ms. Simon, are you?
There's only one reference to working days, and that is right in the beginning of the code, under section 13, which says any person has access to the public part of the register on parliamentary working days and at times prescribed by the registrar. So that being so, I don't then think that working days should be defined, but rather the simple word day, and the definition should be calendar day. Day, and then the definition is a calendar day. So day means a calendar day. And then delete the proposal for working day. day means a calendar day. That is then the proposal, Chair.
Thank you very much, Chief Whip. It's in order with me, Honourable Brinkhuis. Do you have any objection to that?
Yes, thank you, Chair. I think calendar day is a very broad day, Chair. That I think it encompasses even most probably a weekend, also like a Saturday or a Sunday, because it all falls under calendar.
Correct.
So I would rather prefer if it is called a working day or all working days. If it is in order. Thank you, Chair.
Chair, I just wanted to make it quite clear. There is reference to days in the code. So it will say within 30 days, a member must do X, Y, or Z. That day should be defined as a calendar day. There was some confusion because we had put their working day, but there is only one reference to working day in the code. And that is the availability for checking the register. So that being so, and it actually talks about a parliamentary working day, I'll leave it to the committee whether they think that a parliamentary working day should be defined, in which case it could be means a parliamentary working day as per the rules, the standing rules. But the word day, the definition should be calendar day. I'm not sure if that makes sense.
Honourable Brinkhuis.
I think it makes absolutely no sense to me, because the word calendar is a very general word, and it doesn't specify. It doesn't come down to a specification.
Okay,
so
yeah,
Yes.
no, my apologies. You can continue.
I'm fine. I'm fine, Chair.
Okay, I think the intention of that inclusion is that the code already speaks to an amount of days. So there's 30 days that a member has to do X, Y, and Z. So the question that we need to answer is: are we going to specify what days? And I'm no legal practitioner, and the registrar must come in here, but it makes it watertight if we define the amount of days to link it to a calendar day, because you're absolutely correct. 30 days is very often referred to as a calendar day, because if we don't define it, 30 days will stretch over a month, nearly a month and a half, to conclude an instruction of the committee. Honourable Wenger, and then Honourable then the registrar. I've seen your hand too.
So Chair, the Honourable Brinkhuis is absolutely right. Calendar day includes Saturdays and Sundays. So a day on a calendar, whatever that day might be, is included in that definition of calendar day.
All right, thank you. Registrar.
Thank you, Chair. If I could just render some assistance. In South Africa, there are a number of definitions of day. The first one is a business day, Monday to Friday, excluding public holidays. The second one is a calendar day, which includes the weekends and includes public holidays. And there's also a court day, which is specifically applicable to the courts, and it implies a day on which a court normally sits. So that is the closest definition to a business day, because courts do not sit on public holidays. I'm of the opinion that the reason that the day in the code has to be defined is precisely as Member Wenger said, that when it comes to appeals, if you don't define what a day is, does it mean a parliamentary working day? Does it mean a normal business day, or does it mean a calendar day? And these definitions are crucial when it comes to time periods for the submission of documents in appeals. So having said that, I would support the definition to be a calendar day. And the reason for that is that even though people are not working on a weekend, a person who is bound to submit reasons to the appeals committee has nothing preventing him or her from attending to those documents over the weekend, because, as I'm sure we're all aware, parliamentary personnel, parliamentarians, members, do not follow just a normal 9 to 5, 5-day week. They work all the time. Thank you, Chair.
Thank you very much for that guidance, Registrar. Members, Brinkers and Wenger, are we then happy with the proposal with the guidance of as per the guidance of the Registrar?
Chair, member Brankes here. I can't say that I'm happy with the word calendar, like I said in the beginning, because it doesn't. It refers to all the days in the calendar from the 1st of January till the 31st of December. And if I could just let's on one aspect with regard to Saturdays and Sundays. Yes, a public official, a member of parliament, or any public official should be available on a weekend, on a Saturday and a Sunday. In terms of any response to Parliament or any work, what do you call it for that matter. But a public official, a member of Parliament, in that case, has a family also, and that should be always kept in mind. And yes, so the word calendar, it is not going to be appropriate in this instance. So my final input will be that for the word working, or all working days, that will be my final input. Thank you, Chair.
Thank you very much, Honourable Wenger.
Thank you, Chair. Just so that there's no confusion, could we put the word day one line below, because we're not defining working day. Right. Just so that it's clear, we're not defining working day. We are defining the word day. So let's go to the code and see where the word day appears, with your indulgence, Chair, because I think it might be easier for us to deal with it in that way.
All right, and that's in order with me.
Okay, so if we look at the code of conduct from if we go right to the beginning and we look at where does the word, day appear? The first one is in section 11. It says, disclosure of registrable interests shall be within 60 days after the first sitting of a parliamentary term or appointment of a member. 60 days. One would then infer that that means 60 calendar days, not 60 working days. because then that would extend that to, well, I mean, that would then be over a quarter after the member had been signed in and had not disclosed their registrable interests. So in, for example, this instance, do we agree that days means calendar days?
I would say that it would infer that it's a calendar day.
Me too.
And Registrar, my apologies for throwing it back or putting it back to you. But with the submissions, what is the practice as it currently stands?
Chair, since I've been in the post, it has always been accepted that the submission of disclosures is within 60 calendar days of the first sitting, or 30 calendar days in the subsequent, before the 30th of April in the following year. And if I have regard to the previous year's submissions, that has also been the practice, that submissions are 60 calendar days after the first sitting of a parliamentary term.
All right, thank you, members. I think we've had Honourable Wenger. Is that still a hand, or can I continue?
Well, should I continue to look at all the other places that the word day is mentioned?
You could do that, yes.
Okay, so the next reference to the word day is in the penalties under 13.4 says a member of the conduct committee who contravenes paragraph 13.3 is in breach of the code and shall under B be liable to a reduction of up to 30 days salary. Now, I think that in that case, 30 days salary is understood to be 1 month and therefore calendar days.
Okay.
And unless there's a disagreement on that interpretation of 30 days salary.
No, there's. I mean, from my side, it's clear that the intention is 30 calendar days, i.e., 1 month salary. Honourable Brunkes, if you have any comments.
Yes, sir, I will also I will agree that it will be, when it is a 30-month salary, it includes it means a 30 calendar day. Yes, 100%.
All right. So Chief Whip, if I may, with that being said, I think it's clear that the intention of the Act, when it refers to days, is in fact referring to, or the intention of the drafters was calendar days, and for that reason, I would support the proposal of days, meaning a calendar day. Can I put that to the committee so that we can continue? Honourable Wenger.
Agreed.
All right,
Yes,
Honourable.
there's no objections. It's fine. Thank you.
Thank you very much. Members, we then move on to the registrable interest, and there's an inclusion from dependent child for the addition of children.
Agreed. So whether the member has one child or several children, it extends to all.
Yes.
Agreed.
Agreed, Chair.
Thank you very much. Then the family members, Honourable, I see the registrar, my apologies.
Thank you, Chair. Just regarding the registrable interest, might it not be advisable to state the dependent children of permanent companions? It's not necessarily just a minor child that is dependent. Through various circumstances, children can have attained the age of legal majority but still be entirely dependent on that member or that member's permanent companion. Thank you, Chair.
Thank you, Registrar. Members?
Agreed, because we should have consistency, Chair, so it should be dependent child or dependent children.
I agree, Chair. Dependent children.
Thank you, Honourable Brancais. Thank you, members. We now move on to family members that should include minor children of permanent companions.
Should that minor not change to dependent? As per the registrar's input?
Yes, yes, yes. Members, are you in agreement with Honourable Brancais? You're in agreement with the change from minor to dependent?
Yes, Chair. I'm in agreement.
Thank you very much.
So, Chair, just so that we're clear, we're including dependent children of permanent companions under the definition of family member.
Yes, yes, Chief.
Which was not there previously.
Yes. Okay, members, all in agreement? Can we move on?
Yes.
And then there was a proposal that a permanent companion should be further defined. Honourable Wangham.
Chair, as I recall, there is a definition in the code of permanent companion. Is that not so?
Yes.
Currently, as it stands, permanent companion, and I'm going to read from the code, in relation to a member means a person who is cohabiting with the member and is publicly acknowledged by the member as that member's permanent companion.
Yeah, but I think the intention of this proposal was that you might be permanent companions, but you are not cohabiting together.
Okay, so is the proposal to then remove cohabiting?
Yes, I mean that wasn't the proposal, but I think that would make sense to as per the proposals received, because you can be a permanent companion without living together. Chief,
that is true.
I agree, Chair. I agree.
Registrar.
Thank you, Chairperson. Just a minor change. I would suggest permanent companion in relation to a member means a person who has been publicly acknowledged by the member as that member's permanent companion, rather than who is publicly acknowledged. Thank you, Chair.
Thank you, Registrar. Members, do you agree with that inclusion?
I agree, Chair.
All right. And then, members, I think
Sorry, Chair, could I just clarify that, because if that person is no longer that person's permanent companion, say they broke up or got divorced or whatever it might be, they had been acknowledged at what point does that person then remain the permanent companion? If it's in the past tense instead of the present.
That's a good point. Registrar?
Thank you, Chair. Member Wenger has a very valid point, and that's just raised another issue in my mind. If the member and his or her permanent companion part ways, there seems to be no mechanism in the code to acknowledge that. That's all, Chair.
Chair,
Honourable Wenger?
could I then propose maybe that we leave it as is acknowledged? Is publicly acknowledged by the member as the member's permanent companion. Because that would then mean that they currently acknowledge that this is my permanent companion.
And the member, and as it stands, the member then has
An obligation to declare
yeah,
the relevant things for that person.
yes. Okay.
So that we don't then become too prescriptive of, you know, members' personal relationships.
Yeah, indeed. Okay, so Ms. Simon, if you can then remove that, and then just members, I forgot to include that there's more than a person could have more than one permanent companion, and for the inclusion of to make provision for that. So it must be. So it must read, in relation to a member means a person or persons who is with the member and is publicly acknowledged by the member as the member's permanent companion. Honourable Wenger.
Thank you, Chair. Just to help there, so a permanent companion in relation to a member means a person, and then in bracket S,
Yeah.
publicly acknowledged by the member as that member's permanent companion, bracket S.
Thank you. Simon, did you get that?
Chair, I can't open the code now, but I assume there's another section where is must be added. If I heard correctly now.
Yes, under person and next to person. Honourable Wenger.
Yep.
Okay. Yep, that's perfect.
Chair.
Honourable Brankas.
Yes, if I could come in there, I was just thinking now that the term made public by the member, what would that entail? Because as far as I'm concerned, 2 or 3 people can also be, if it was disclosed to 2 or 3 people, that could also entail public or mean public.
I think the intention there is for at the discretion or the responsibility rests with the member. So if you acknowledge that this person is your companion, you have an obligation to declare that person's interest. If you as the member do not declare and acknowledge that person as a permanent companion, then the responsibility is yours as the member.
Yes, exactly. And what you is that what you mean by declare, to make public?
No. You don't need to make it public. You publicly acknowledge it. So if somebody says that you are with person X, and you then acknowledge that person X is your companion, that is a public acknowledgement. I'm not saying the intention is
Okay.
not to
Yes.
publicly broadcast it on Facebook that you are in a relationship with person X. Honorable Wenger.
Thank you, Chair. Also, I mean, if you marry somebody or go into a cohabiting agreement with somebody, all of those would be considered a public acknowledgement by the member that this is their permanent companion or companions.
Yes, that makes more sense.
All right, thank you, Honorable Brinkers. That is, members, those are the submissions received. We've gone through them. I'm now going to allow, as previously indicated, the registrar to make to put up the proposals that the registrar is making for us to consider and discuss. Okay, registrar, when you're ready.
Thank you, Chair. I see the time is marching on. I'll try to be as brief as possible. Turning first of all to the Code of Conduct Act. The Code of Conduct Act says that a member means a member of the Provincial Parliament and includes a member of the Provincial Cabinet. The definition in the code does not state that it includes a member of the Provincial Cabinet. It's just confusing. In addition, there is a problem with a conflict of laws between Executive Members Ethics Act, EMEA, the Executive Members Ethics Code, and the Provincial Code of Conduct. So the proposal I'm making is Section 2A. Members of the Provincial Executive must comply with the provisions of the Executive Members Ethics Act and Code of Conduct applicable in terms of that Act. The effect thereof is to remove the Cabinet members, the Executive, from the provisions of the Western Cape Provincial Parliament Code of Conduct. The reasons for this will become clear as we carry on. If we have a look at Section 2B of EMEA, it reads as follows. It must include provisions prohibiting cabinet members, deputy ministers, and MECs from undertaking any other paid work. However, the Western Cape Provincial Code of Conduct states that provisions prohibiting members from undertaking any other paid work without obtaining prior permission from the, pardon me for that typo, from the party of which they are a member. Since the Act extends the code to include members of the Executive, there's a conflict between these two sections. So my proposal is that Section 2.4c should be amended to read, require the members other than the members of the Provincial Executive to disclose to the registrar. There follows a very detailed exposition of the problems that I've found. EMEA is national legislation. EMEC is also national legislation. And there are conflicts in these two codes of conduct. In terms of EMEA, the limit on gifts is 350, whereas in terms of PP, the limit is 1,500. There was a bill tabled in the National Assembly in 2011 to amend EMEC in order that the value of gifts be increased to 1,000, but I could not find any indication that that bill had been passed. Executive members can thus exclude all gifts under 1,500 in terms of the WCPP code and claim that as the code extends to the members of the Executive, as far as financial disclosures are concerned, that he or she has complied with the code. Since it's common practice but not official policy that executive members merely forward their WCPP disclosures to the Cabinet Secretary in terms of EMEA, the distinct possibility exists in my mind that the information supplied to the Secretariat is non-compliant with EMEA, only with the WCPP. A further problem arises in that where a member of the executive is offered a gift in excess of R1,000, that member has to request permission to retain the gift from the Premier. Should such permission not be granted, the member must either return the gift or donate it to the state. No similar provision exists in the Provincial Code of Conduct. When a member, in terms of EMEA, makes a disclosure in terms of paragraph 5, he or she must also confirm in writing to the Secretary that the member receives no remuneration other than as a member of the executive. In other words, that is a positive statement. The member is required to state in writing, I do not receive. The wording is specific. No such provision exists in the Provincial Code of Conduct. Merely authorization by the Chief Whip of the party concerned if the member does have remunerated employment. The net result is that unless an executive member files a distinct and separate return with the Secretary to Cabinet, the member is de facto in breach of EMEA. And then going on further, as has already occurred, a transgression by an executive member must be investigated by the public protector in terms of EMEA. However, it may also, and in fact, as it currently stands, it must also be investigated by the registrar. This leads to an inevitable conflict where the PP may exonerate an executive member, but the registrar may recommend that the member is in fact guilty or vice versa. The result could be a plea of autrefois convict or autrefois acquis for the member concerned in resisting one or the other of the two investigations. Fifthly, in respect of penalties that may be levied on a transgressor, the WCPP's code penalties are very narrowly described. Not so for the penalty provisions of the PP, who has the prerogative to dictate remedial action which must be complied with. This leads me to the conclusion that the members of the executive are held to a far higher standard than the ordinary members of the parliament. Lastly, and this one is, in my opinion, critical, only the president or premier, as the case may be, the public protector, the secretary concerned, and that means the secretary to the cabinet, and staff designated by the secretary have access to the confidential part of the register. At present, the Conduct Committee has access, as do I, to the confidential part of the register in respect of executive members. Yet this is in direct conflict with the provisions of EMEA, since none of the members of the committee or the registrar have been designated by the secretary to have access to the confidential sections of the executive's return. It's trite that subordinate legislation cannot trump national. Hence, to resolve the conflict, I submit that the two disclosures must, as a necessity, be separated. And we can just skip the conclusion. It's merely a summary and go on to the next point. Could you just go up a little bit, please, Lynn? Okay. Yes, Code of Conduct Act. Section 2.5, the Code of Conduct may prescribe any maker. That's a typo in the Code of Conduct Act that should be corrected. It's in the text as published by Sabinet and appearing on the WCPP website. Section 5.2 of the Act should be amended to read that the complaint must be in the form of an affidavit. The Code of Conduct requires complaints to be in the form of an affidavit, hence Act and Code should concur. Moving on to the WCPP Code of Conduct definitions, corporate entity includes any public or private company, any association not for gain, Section 21 company, etc., etc. The reason for that is that the Section 21 company is a juristic person, and hence the juristic person, the company, may not make a profit in terms of the law. There is nothing, however, to stop the company paying its directors handsome salaries which might otherwise remain undisclosed in the financial disclosures. We've dealt with Day. If we can go up, Lynn. Keep going, keep going. Other way. Okay, dependent child. There's no definition of dependent child, and I would suggest it means any child of the member who is not capable, not financially capable of supporting him or herself, whether born in or out of wedlock, or who has been formally adopted, or any child where the member has accepted financial responsibility. It's become common in other jurisdictions, particularly in Canada, to broaden this definition, to give recognition to the fact that not all children are born in wedlock, others are formally adopted, and others not being formally adopted nonetheless enjoy the continued financial support of an adult. In addition thereto, recognition has also been given to the fact that certain children may not presently or in the future be capable of supporting themselves despite their having attained the age of legal majority. I would submit that the definition recognizes this fact and extends protection to them. Family member, we have dealt with. My recommendation or my suggestion was that member's spouse, parents of the member, sibling of the member, or his or her spouse. And the reason for that is that EMEC makes provision for the disclosure of interests held by members' parents, but that might just be for the executive. And we also know that it's become quite common, unfortunately, for corrupt activities to be disguised by the interposition of a sibling, spouse of a sibling, or other members of the parliamentary member's extended family. However, that is for the committee to decide. We can carry on. Permanent companion we have dealt with. We can carry on. Registrable interest. If the committee decides to amend the definition of family members, then the definition of registrable interest has to be amended, and it should, I see there's an omission, it means the financial interests, etc., etc. Fine, we can carry on. Declaration of interests, declare any personal or private, etc., etc. His or her family member or business partner. Now, business partner has not been defined in the code. I think it would be apposite to have a closer look at this and define business partner to exclude any sort of possibility of things being concealed. Carry on, section 5, the same business partner. Section 7, remunerated, a member other than a member of the provincial executive subject to the provisions of EMEC may only engage, etc., etc. Addition clause 3, a member of the provincial executive may not, in terms of EMEC, engage in any other remunerated activities. I've dealt with that. Section 10, we can keep, yes, confidential. The registrar must record all details. Sorry.
My apologies, Registrar. I see Honourable Wenger's hand.
Sorry, Chair, may I ask a quick question?
Yes, sure.
When the EMEA refers to provincial executive, does that include the executive of the legislature or not?
It, Member Wenger, as far as I can ascertain, it includes the members of the provincial executive and includes the Premier. So in other words, it would be all the provincial ministers and the Premier.
Yeah. And excludes the executive of the legislature.
Yes.
Thank you.
Section 10, confidential, the number, nature, and nominal value of shares of any type in any public or private company or close corporation or any other corporate entity. Now, this section, as it is currently worded, and the following sections are confusing in that prior to these sections, there is a very specific statement that the following information must appear in the confidential section. This has led to confusion amongst members when filling in the forms and confusion with the registrars prior to myself. So I've suggested that we include section B, the details, including the extent of the member's interest in any trust, either as a trustee or a beneficiary. That puts it beyond any doubt. The value, C, the value of a member's financial interest in any corporate entity, not a corporate entity. The amount of any remuneration received by the member for any employment outside the PP. The amount of any remuneration for any directorship or partnership or arising from any partnership in which the member is a partner. Details including the address of any residential property owned by the member, either wholly, partially, or in trust. I've removed the word private. The monetary value of any pension received by the member. The reason for that is that the majority of members, when they fill in this section, they include pensions and retirement funding to which they are still contributing, which is of no sense or value to anybody. The monetary value of any pension received is, however, in my opinion, what is intended. Ownership and any other interest in land or property in or outside South Africa. Description of and the extent of the land or property, area in which the land or property is situated, and the nature, value, and extent of the interest in the land or property. Pensions. The source of any pension the member is currently receiving and the value of the pension. At this point, I must just point out that all of these refer to information that must appear in the confidential section. You will see later on that a lot of this is repeated in the public section, but with changes. Remunerated employment outside the PP, type of employment, name and type of business, amount of remuneration. Consultancies, the same. Yeah, and then I think after consultancies, directorship and partnerships, the name and business and type of business activity of the corporate entity or partnership, and the amount of any remuneration received for such directorate, etc., etc. Sponsorships, the source and description of direct financial sponsorship or assistance from any source other than the member's party, which benefits the member in his or personal and private capacity, and the amount or value of the sponsorship or assistance. What I've found is that this section created confusion amongst members, and I took the liberty of rewording it to make it quite specific. Details of all the financial interests of a member's family member as set out above. Now, there is a marked difference between a person's financial interests and the said person's registrable interests. There's no definition of financial interest. It might be advisable to have another look at this and reword the subsection to read registrable interests of a member's family member, because those are what are set out in the code. Members' liabilities, that's fine. Public disclosure section, again, This is repetition. A member must disclose the following registrable interests held in and outside South Africa, and details of that was superfluous. I took that out. If we carry on down the page, the number and nature of shares of any type in any public, etc., etc. You'll see that I've removed nominal value because earlier in the code it says that the nominal value must be reflected in the confidential section. As it was previously drafted, the disclosure form included nominal value in the public section, and this again created huge confusion amongst members. And if you follow this through, you will see that there are very much the same sort of requirements. So if we keep going down, I'm not going to go through each one. I think members could just have a look at this. Keep going. Right, C, clause C, if you can go back up a little bit, other way. Ownership and any other interest. Clause C is important. The nature, value, and extent of the interest in land or property. This again caused confusion with members because members who are married in community of property or those that have joint ownership of property would not know whether they should list their share of the ownership in the property here or in the confidential section. Here, it has to be in the public section. So if you're a 50% owner of the property, you have to say extent of interest 50%. Pensions, again, that's just to clear up confusion. Remunerated employment, that just cleans up the requirements in the public section. Consultancies, the same. You can keep going down. Directorships, partnerships, the same. Sponsorships. If you could just stop there. Again, this created confusion with members who had received sponsorship in that they weren't sure what to list under this section. So this section has been reworded to make it very specific. Okay, gifts and hospitality, family member. Okay, that just says that the family members must show all this in the confidential section of, no, public section. Okay, can keep going up. Yes, if you could stop there's an unexplained difference. Hospitality intended as a personal gift versus hospitality intended as a gift. The removal of personal, in my opinion, widens the definition and forces greater disclosure, which I believe can only benefit the image of Parliament. Foreign travel, if you can go up. Foreign travel other than personal visits, particulars of the sponsor. As previously worded, it was a bit confusing. Any other benefit of a material nature, that I think is self-explanatory. Okay, section 13, only the conduct committee PP registrar and his or her designated staff. So again, the conflict is that if the executive is not separated from the normal members of the PP, the secretary to cabinet has access to the confidential part of the register. It just does not make sense. Let me just get to this section 4. Okay, if you could just go up a little bit further, please, Lynn. A bit more. As it currently stands, if I, as registrar, forward a copy of an executive member's form to the cabinet secretary, I'm immediately in breach of the code, because the code does not grant me the power to disclose any confidential part of the registrar to register to anybody other than the members of the conduct committee and the public protector. Advice and counsel to members. A member may approach the registrar to obtain personal advice and counsel in regard to any matter that may concern the application of the code. My experience has been that members approach me regularly for advice in regard to everything surrounding the code, not just to gain information regarding a suspected breach of the code. And I'm of the opinion that members should feel free to approach the registrar for advice regarding the entire code, not only suspected breaches. Section 26, the member, the complainant, the registrar, and any prospective witnesses shall be given a minimum of 10 days written notice. The section has no provision that notice is given to the registrar of a hearing. Appeals committee we've dealt with, so I think that is the entire document.
All right,
Yes.
thank you. And
Sorry,
registrar, continue.
Just the last part in considering an appeal. In hearing evidence, what I've put there is in considering the appeal, the appeals committee may request the registrar and the appellant to provide written evidence and argument. The reason for that is generally, if it gets to this stage, there's been a hearing, there's been correspondence, there's been documentary proof. The appeal should then just work solely on the documents. And that is the sum total of my submissions, Chair.
All right, thank you very much, Advocate or Registrar. Thank you very, very much for the detailed presentation. Members, do you have any questions on the presentation? Honourable Wenger.
Thank you, Chair. I'd like to thank the Registrar for this very comprehensive submission. Just as a first point of departure, the initial part talks about amending the Act, which then requires an amendment bill, which we're in your hands, which I assume would be a bit of a longer term project for this committee. At the moment, we're looking at the code, which the committee should report back to the House on its efficacy annually, and in that we're making some proposals for its amendment. So I wonder if we could then perhaps separate those two things out, looking at an amendment bill and the proposals for the efficacy of the code itself. Because to my mind, those are two different projects.
Thank you. Honourable Brankes, was there a hand?
Yes.
Thank you, Chair. I think that was a lot to divulge from the registrar for the moment. But very interesting point that he brings up with regard to the executive, the cabinet members, and the difference between the members of the parliament and the executive. I would like to have more clarity on that before any amendments are actually made to that, or any proposal, any other proposals made to that input from the registrar. Yeah,
That is from my side. Thank you, Chair.
Thank you very much, Honourable Brinkhuis. I think if members, with your indulgence, I'm going to deal with the proposal made by Honourable Wenger, and that we in fact split the two, so that the amendment to the Act will be a longer process or project for the committee to work on, because there's obviously legislative processes that needs to be followed before we can make any amendments to the Act in its current form. Members, so that's the first. Honourable Wenger.
My apologies, Chair. I neglected to mention that perhaps in our report to the House on the efficacy of the code, we could make reference to the fact that that the Code of Conduct Act may require some amendments, so that we do inform the House that we are looking at this. Okay, perfect. You then covered the last part of my proposal, that we will include that into the report of the amendment, or the report to the House. Are we all in agreement with that, Registrar?
Yes, indeed, Chair. It's absolutely necessary that is followed as laid out by Member Wenger.
All right, thank you very much. Members, and then the other proposals, do you have any other additional comments or proposals, questions to the Registrar on the proposals made for the second part of the presentation?
Nothing from my side, Sir.
Thank you very much, Honourable Wenger.
Thanks, Chair. I think we need quite a bit more time to then go through each of those. So I'm not sure how you'd like to then proceed on that.
All right. So if you don't have any questions of clarity, I want to make the proposal that section of the presentation be circulated to members, and we will then have another meeting there where we can go into it line by line, like we've dealt with the submissions made today, if that's in order, members.
In order, Chair?
In order, Chair, yes.
All right, thank you very much. Thank you, Registrar, for the detailed presentation, for all the work that went into it. It's duly noted and appreciated by the committee. Members, we have now come to the end of that part of the agenda. I want to ask if we could now go. Yes, Honourable Wenger.
Sorry, Chair, just to understand what then happens to the proposals that the committee has agreed to.
All right, so the proposals have been received, that's been deliberated, and has been approved. So we will now, in a report, we will draft the report with these amendments as agreed to by the committee. It will be circulated to all members via electronic format before we to sign off as soon as possible, and then that will go to the House for agreement.
Thank you.
Okay, members, if you don't mind, if you could give me 2 minutes just to I just need to do something administratively quickly. If I can ask for your indulgence for 2 minutes.
That's fine, Chair.
members, we will now deal with the minutes of the 14th of August, page 1, any edits or amendments? There's no report tabled, or you're not going to table a report today, am I correct?
That is correct, Chair. There is no report from the registrar. I think that the proposed changes would constitute my report.
Right. Thank you very much. Members, and that's the end of the agenda. That's all from my side. Are there anything that you would like to add? I see the registrar.
Chair, I would just like to inquire if it would assist members if I compiled one bundle of documents comprising my proposed changes, the Executive Members Ethics Code, the WCP Code, the Provincial Code of Conduct Act, as well as EMEA, so that they are all in one bundle. Thank you, Chair.
Thank you very much for that proposal and suggestion. Members, are there any objections to the proposal made by the registrar?
No, Chair, but just to be clear, the amendments for the bill are will be removed then for the separate consideration? Or is the intention to have it all put together?
Chair, the intention is that I will take my document as presented to the committee. I will separate the Code of Conduct Act amendments as a separate document, and then in addition to that, I will attach to the documents copies of EMEA, EMEC, the Provincial Code and the Provincial Code of Conduct, to save members the time in sourcing all of these documents as they peruse the proposed amendments. Thank you, Chair.
Fabulous.
Right. Thank you very much for that proposal and offer, Registrar. Members, are there anything else that you would like to put onto the agenda?
Nothing from my side, Chair. Thank you.
Honourable Brinkhuis.
Nothing from my side, Chair. Thank you.
All right. Thank you very much, members. That brings us to the end of this meeting. Allow me an opportunity to thank Ms. Simon and Mr. Iso for the technical and procedural and committee support that they've provided. Members, thank you very much for the effort and the time that went into for the deliberations on the proposed amendments. I think that we've made some good progress, and yeah, we couldn't. I'm very grateful to the committee for the work that went into that. So from my side, the meeting is adjourned.